Yeah.
We're going to do a trial with something else where you register.
Mm-hmm.
I'm going live. I'm going live.
Oh, okay.
Thank you.
I'm live right now.
Okay, Jella, hit it.
Good morning, everyone. This is the public review session for July 28th, 2020. This is a review session. No testimony will be permitted. Appeals calendar, new cases. Item number 20, 2019-90-A, Rivers 2432 Joralemon Streets, 10, 20, 30 Columbia Place, Brooklyn.
This hearing was initially scheduled for the April 6th, 2020 session, but was postponed until today. We have proof of service of initial application to officials and interested parties. We have proof of service to officials and interested parties of notice of this teleconference hearing with dial-in information. I note that this application was first filed in May of 2019. So an update on the current status of the project should be provided by the appellants. We are being asked to determine, I think, whether the tenant safety plan that is needed to allow excavation of the courtyard area to install a parking garage in the cellar is adequate and complies with Building Code Section 28-104.8.4, although DOB has reviewed the materials many times according to the timeline that appellants provide. I note that these buildings are located in the historic district and that the Landmarks Preservation Commission has strict protocols for the maintenance and structural integrity of historic structures. The owner should produce the certificate of appropriateness and Landmarks Commission approved plans for the project. I recommend that our own counsel reach out to the Landmarks Commission to see whether they have been monitoring the project in terms of has to do with stability of surrounding properties. I also asked whether Department of Buildings has inspected the site to verify that the owner's proposed egress routes exist or will be viable once excavation starts. And also if fire department could take a look at the site if they haven't already done so. And of course, I deferred to Commissioner Sheta about the structural concerns expressed by tenants and their consultants, but the drawings provided by appellants include supportive excavation, structural framing, and foundation plans, which I think appellants argue is not been considered, so they are provided. I note that there are many projects in the city where cellars have been excavated under occupied buildings and where multiple stories have been added to them as well. So this is not an unusual phenomenon to excavate a cellar under an occupied building. Reviewing the tenant safety plan, drawing T-1.02 and related drawings stamped approved November 15, 2018. There is a statement that there will be no structural work inside the buildings. Owners should verify that the ramps to the parking garage are not located under the building. I think when I'm looking at the drawings, I see it's not located under the building, but I just want to have them verify. For me, the issue of proper egress during construction is fairly simple and resolved with carefully drawn building and site plans that depict current conditions based on field inspections and measurements, and depict how those conditions would need to be altered to respond to construction, and then how they would again be altered once construction is complete. Endless wordy analyses by architects hired by the appellants in an attempt to kill the project are actually not helpful to me. The owner should respond with properly prepared drawings if they have not already done so in their ongoing engagements with the Department of Buildings and Fire Department, because we may not be seeing all the drawings that were submitted to show the egress compliance. The owner's architect should attend the hearing so that they can respond to those questions. And the main reason for asking for this is appellant's contention that the safety plan does not represent field conditions. So an architect going out and actually inspecting the site and measuring for field conditions, the architect signs and seals the drawings. And so we can rely on this. It's a professional certification, right? So my position is, so rather than debate whether the text of the administrative code is being met by owners' submissions, drawings that represent actual field conditions should be provided, and DOB and fire department should review them, and that would be that. I don't see the point in going back and forth with text. Commissioner Vice Chair Shonda?
Thank you, Madam Chair. I agree with you. I think this really, given the amount of back and forth and amount of review that DOB has done, and in terms of the consistent manner in which they have reviewed it with other similar cases, as you mentioned, cellar building, digging the cellar and building in the cellar is not an uncommon feature. So all the measures and analysis that DOB has done, I would think, quote unquote, is somewhat routine in DOB's parameter. And so they are applying the similar measures. So I find the appellant's argument not adequate to rescind the permit, but I would like DOB and FDNY to just weigh in on it and give us that confirmation.
Okay, thank you. Commissioner Otley Brown.
I agree with what both of you have said, but I was wondering if it wouldn't be beneficial to the tenants if DOB and FDNY did a walkthrough with the plans and a member of the tenants, because I think that this doesn't have to be so adversarial. Perhaps if they did a walkthrough together, then DOB could explain its position and also see the field conditions actually, live. And then maybe both of them could come to a determination that adequate protections are in place, or tweak the plan if it needs to be.
Okay, there. Good idea. And we've had a good experience in another project where we and tenants and fire department and DOB did a walkthrough of another building that was actually very helpful. Thank you. Commissioner Sheta?
Thank you, Chair. I agree with what is said so far. I want to start with saying that it's not impossible to erect a project like Subject 1 while ensuring the structural safety of adjacent buildings. Of course, if they are in like healthy structural condition, not deteriorating, and which I believe is the case for the adjacent building, the subject of part of the subject of this appeal. So this is nothing like, not extraordinary. The project could be done safely, reasonably, but some attention need to be like paid to the details. I don't feel that there is like a cooperation between the tenants, the owner, even from the side of the DOB. I feel like they just got the documents, filed them, and like usual, they don't have time to probably criticize and dive deep into the details. I did take a look at the SOE drawings, and I understand that one of the points that's raised by the appellant is that TPP2, the second revision of the TPP, included a statement saying that no structural work in the adjacent building. And this is I'm reading from the document that's submitted to the DOB and submitted to us by the appellant. It says structural safety dash no structural work in the residential buildings is proposed under this application. I believe this is a misrepresentation. If it did say, like you, Chair, said, inside, that would be different. Inside means to like perform that kind of work, you need to get inside the building. But in the TPP, it says in, which means that this structural work is associated with adjacent building. And let me say that it's not a requirement for the TPP, as far as I understand, that no structural work is done, but the requirement says no structural work that may endanger adjacent building is done. And if I have a reasonable structural engineer, and the question is, can this structural work in like the SOE or the underpinning or whatever, could it be done without endangering the adjacent building? The answer is yes, provided that technical attention paid to the details. Like somebody should look at the SOE drawings, make sure that they are okay, the might be peer reviewed. I don't know. But this is the first point I want to make. So in my opinion, I believe it was a discrepancy in the statement made in the TPP 2 and the facts. The facts are it's going to be structural work done in the adjacent building. Would this endanger the adjacent building or buildings in general? Generally speaking, no, it's not necessarily going to do that. But when I looked at the SOE drawings, I did see some alarming things. I got some concerns. I hope somebody take a look at these, and I hope I didn't run any numbers, I didn't do any analyses, but I did look at some sections, and I believe they need to be re-looked at. And I'm sure whoever is doing the SOE is going to be able to take a look at them, and if he sees something that need to be changed, they could change them. As simple as that. I don't believe the matter before us is very complicated. It's this kind of work is done on daily basis in the city, and it's not rocket science. I would like to hear from the DOB on the reasons why the permit initially was set to be revoked, and after the submission of the second TPP, that was backed off. That action was backed off. So what did it change? Was it that second TPP that included something that is not included in the first one? I would like to get some information on that. And like I said, the SOE drawings, I have seen some sections in them. They need to be looked at. I saw a structural engineering report dated July 13 from Mr. Bill Coleman. He's a PE. He indicated that the adjacent 6-story building is founded on uncompacted fill. This is the way he described it. I don't understand how, but it's an old building. It's possible. But he continued to say that the proposed structural work in the existing building, which is underpinning, includes underpinning, partial underpinning of that building, meaning that the side adjacent to the excavation will be underpinned. The other side, the far side, will not. So his point is the building now is going to be supported in two different types of foundations. From one side is underpinning piers, from the other side is uncompacted fill. And I cannot provide an opinion on that because I don't have a geotech report, so I can't tell. But one of my concerns is that the underpinning piers under the 6-story building, the 6-story building is in and out. If you look at it, if you look at the facade next to the adjacent construction, it's in and out. It's not a straight line. So one of the things that they put underpinning piers on the outside portion, but inside and the two legs of the U, they didn't put underpinning piers. I have concern on that. And the greatest concern I have is on the section that footing that's inside from the underpinning pier. If you look at the section in that portion, it's a cantilever. It's, I believe it's 15 feet or so cantilever about. And the wall itself, the soldier pile and lagging wall, it's not a very stiff wall. It's just 10-inch diameter pile. So it could deflect, and I'm afraid that if it deflects, that's gonna impose some settlement on that 6-story building. And depending on its structural health, they can see cracks and start like to be not nice situation. So I would urge them to take a look at them. In general, the SOE drawings are not that great appearance-wise. They are not clear. I couldn't read through them clearly. So if they can provide us with a more clear version of that, that would be appreciated. We can take a look at them. But that's all what I got.
Mhm. Just to clarify, the SOE drawings, you mean the resolution of the drawing that you received is not that legible? Is that
Yeah.
what- Yeah.
Yes.
Okay. Okay. All right. Thank you. And Commissioner Shabeta?
Thank you, Chair. I did not have many concerns up until Commissioner Shetta spoke. I think that we should, I am eager to hear the responses to his comments. And once Commissioner Shetta is satisfied, I see that we can move forward on this case.
Mhm. Okay. Okay, and I just want to add that for full disclosure, I was on the Landmarks Commission when this application first came, so I was one of the commissioners who looked at this and probably voted in favor of the application for the underground work. I don't know actually how I voted, but possible. Okay. Anything else? Any last minute comments? No? Okay.
Item number 21, 2019-295 BZY 428-432 East 58th Street, Manhattan.
Okay, we have proof of service of notice of this teleconference hearing with dial-in, but it isn't clear actually. Actually, we got further clarification on to whom it had been delivered. So that was something that was missing from the file, but now we have it. It was delivered to all the necessary officials. We received an email on July 14th and the same in letter form on July 22nd from what turns out to be former opposition counsel complaining that it wasn't provided with notice. We received an email on 7/23 from opposition counsel indicating that it no longer represents the East River 50s Alliance. So I'm not really sure whether there's organized opposition on this anymore. We also received an email from Councilmember Kalos on July 14th stating that the package containing the application materials and notice of hearing was received at his district office, but complaining that service was improper and citing to one of the local laws. So I just want to clarify how service works under the BSA rules and the law for the benefit of Councilmember Kalos. Under current BSA rules 1-06.4C, 1-06.5C, 1-07.4, and 1-07.6, neither application referral nor notice of hearing is required to be served for applications to renew building permits for projects that were previously granted vested rights by this board, nor for extensions of time to complete construction. Board staff in this case determined that service to officials would be required as if it were a different type of SOC application. And that was simply because the case has been controversial. Proof of service via United States Postal Service tracking printout shows USPS delivery on July 7th to officials. Councilmember Kalos refers to in his email to Local Law 93 of 2017, which requires proof of service. be announced on our website or mounted on our website. The way that the BSA handles that is proof of service is provided by a USPS tracking receipt. An announcement of proper service is recorded, as it was just a few minutes ago, on BSA's website by the chair's statement at the beginning of each initial hearing session and memorialized on BSA's YouTube channel in compliance with Local Law 93 of 2017. The board, I might add, never proceeds with its initial hearings if it finds that service was defective. That's our standard operation. The summary of litigation provided by applicant on April 7th, 2020 is inaccurate in that it states the BSA decision on the vesting application, which I add is calendar number 2017-320-BZY, was July 27, 2018, rather than June 26, 2018. The resolution issuance date is not part of the BSA resolution online record, although the litigation time clock does start on the date of issuance, and applicants should provide a copy of that 2017-320 BZY, which was not included in the materials. That application was approved to allow completion of foundations with 6 months less 6 weeks from the decision on June 26, 2018. The terms of the 11th zoning resolution section 11-331 grant require the project to be complete and a certificate of occupancy obtained within 2 years of the zoning amendment date, which was November 30th, 2017. That's the date of the city council vote. So construction had to have been completed by November 30th, 2019. This application was timely filed on November 18th, 2019. Based on the construction timeline provided, foundations were completed by October 2018 within the allotted 6 month less 6 week period, and construction of the superstructure and balance of the building is still ongoing with slabs and concrete columns poured as of November 2019 to the 38th floor out of 65 floors, and 86 million in expenditures representing 26% of the total project cost. The percentage of work and expenditures completed as of August 2019 is supported by the executed standard AIA requisition for payment and the October 10th, 2019 wire transfer receipt and construction progress photos. This board, under section 11-332 of the zoning resolution, is therefore permitted to grant a first extension of time to complete for a period of 2 years from the expiration of the last permit in November 2019, provided that the board finds that substantial construction has been completed and its substantial expenditures made subsequent to the granting of the permit. In its statement of facts, applicant states that the tolling period applicable to section 11-332 applies to the time to complete construction as of the November 2017 amendment date. I don't actually know, and maybe council could research this or applicant could research this. I don't know whether BSA has opined on the language of this provision before, but I read this rather as tolling of the 11-332 grant, since it's in the 11-332 section. So according to my reading, the 11-332 grant must issue, and the tolling period begins on the date of issue until entry of the final appeal order, if such litigation is, quote, affecting the validity of the permit. The applicant is arguing that the tolling occurred after our initial determination that the application, that the building vested, and I don't read it like that. And so I read it that they must make this application timely the way they did, and then it tolls while there's litigation that might affect the validity of the permit. I note, based on the April submission, that the lower court's decision on the Article 78 issued on January 8th, 2020, and a motion to appeal was filed on February 21st, 2020. Applicant should advise us if there has been further progress on the Article 78. In short, sorry for the long-winded discussion, but in short, the applicant has certainly met the findings to permit an extension of 2 years from the date of the last permit lapse in November 2019 to complete construction. And to Vice Chair Shanda.
Yeah, thank you. Based on the review of the documents provided, I agree with you. The applicant does meet the BSA standard in terms of the proof of initial service, and more importantly, what is before us. The applicant has indicated that it has met the 1130, 322 and 332, I'm sorry, and substantial construction has been done and should be granted this extension.
Okay, thank you. Commissioner Ali Brown.
I agree with both of you that it's clear that the applicant has met the findings. The substantial work completed of 38 out of 65 superstructure floors brings home the point to me. I'm okay with this.
Great, thank you. Commissioner Sheta.
Thank you, Chair. I would say I'm glad to get a chance to like talk on that appeal one more time on that case. I just want to say something very, very clear that when we decided on this case for the vesting, I recall that what was done by the board to make sure that this application is vested, it's never been done before, at least from my side. I went on like very technical things regarding the pool dates, the closure, all these kind of details were like looked at very, very carefully. And that's how we made our decision. For the current application, I believe based on the submissions that made so far, I believe they meet the findings. And I'm ready to vote on this today, if available.
Right, well, we can't vote on anything on the same day, but we could.
I'm saying if this is what we do, but it's not.
Okay, thank you. Commissioner Shveta.
Thank you, Chair. I too agree with my colleagues. I believe that the findings are met here. I do want to know the position of the board with regard to the councilman's request for a date to respond. While we can close and put this on for another date for Mr. Kalos if he'd like to respond to this application. I'd like to know what the position of the board is with regard to that.
Right, well, I think we don't have a position until we have a hearing, so, right, let's hear what they have to say, because at this point, there's been no submission other than to complain that service wasn't proper, and in fact, service was proper. So, and I do have to say that knowing that the permit would lapse in November, the opposition should have been on alert that there's going to be an application filed, and then they could file. I mean, they're on alert about the building department filings and so on. So, okay. I think anybody else? Any other comments? No? Okay, thank you. All right.
Okay, we will begin the public hearing portion for July 28th, 2020 at 10 a.m. Appeals calendar, new cases, item number 2019-90-A, 2432 Joralemon Street, 10-2030 Columbia Place, Brooklyn.
Okay, the only person in the waiting room at the moment is someone named Steven's iPhone. I don't know if we have.
So Stephen Dobkin is listed, so potentially
Okay, all
could
right.
be associated here.
We're gonna admit him and see if anyone else. When you can hear us, Stephen's iPhone, please state your name, and especially your last name.
I'm Steve Dobkin, the attorney for the Riverside Tenants Association. Can you see me?
Can we? I don't think your video is on.
I press start video. I still don't see myself.
I
can
could
see
see
you.
you.
Yeah, I can see you, yeah.
Okay, thank you.
Can you tell us also, I see Kenneth Fisher and Emily Hill Wright. Is that one of the people in your team?
No, our team includes Chaim Gross, who's our architect, who was supposed to Zoom in, and I assume that he had, so he should be waiting.
Okay, well, he's not in the waiting room, so we can give it a second. Is that Ken Fisher who just came in? And if yes, identify yourself and tell us what.
Good morning. Good morning, Chair Perlmutter and members of the board. My name is Ken Fisher. I'm a member of the law firm of Cozen O'Connor, and I represent the property owner.
Okay. Thank you. And then we also had one other person. What was the other person who joined in?
I believe it was Benjamin Hillwright from the Department of Buildings.
Oh, Emily Hill Wright. So you think it's,
I believe we need to rename.
okay, so I'm admitting because that person disappeared again. Okay. Mr. or Ms. Hillwright, can you state your name, please? If you can hear us. I don't think their audio is on. I don't think the phone Emily Hillwright's audio is on. I only see the video indicator. Yeah, it jumped out again. Okay, so I'm not sure. So that's DOB, who definitely should be speaking on this, but why don't we begin and hopefully DOB will join in shortly. Maybe, can somebody text DOB if you have access to Mr. Hillwright's info? And let them, oh, there we go again. Let's try again. Not sure what they're, there we go. That looks more promising. Okay.
Please
Mr.
state your
Hillwright,
name.
when you can hear us, please state your name and turn off your YouTube video. I think we lost them again. Yeah, there we go. Benjamin Hillwright.
Sorry. Can you hear me?
Yes, we can hear you and now see you. And indeed, you're a Benjamin and not an Emily.
Apologies.
Okay. Okay, good. We can proceed now. I believe it's Mr. Dobkin's show.
Thank you, Madam Chairperson. We listened to the meeting, and of course, the Tenant Association would be happy to meet with a representative of the Department of Buildings and walk through the courtyard. And in fact, we're anxious to do that because I think that our main point in this appeal has unfortunately been overlooked, at least in the discussion that took place. We have a very grave concern based upon the drawing T00102, which is the tenant protection plan, that there's essentially no way out of the courtyard in the event of a fire or an explosion, and the rear and egress in the rear, which is the courtyard, is necessary. The plan that the owner's architect has prepared essentially indicates that any ability to leave that, to get out of that courtyard to a common, to a city street is eliminated, that there is no exit discharge, which is one of the main elements of a means of egress. And the drawing itself appears to be fairly clear about that. And we have submitted in my argument and Mr. Gross's report photographs and his juxtaposition of this particular drawing with other drawings to show essentially, well, let me begin by saying that the drawing depicts or appears to indicate that people can climb down the fire escapes, get out into the courtyard, and then walk out an opening that is portrayed between the two sets of buildings to Girolamo Street. And as we've, I think, pretty carefully demonstrated, there is no opening there. That is a building. There's a one-story building that occupies that area that is not depicted in these plans. And in fact, the only way that the 150 approximate apartments, the tenants in the 150 apartments in both of the buildings will be able to get out of that, that purported egress, which does not exist, would be to climb up a ladder, which does not even lower to the courtyard level. There's a single ladder, and then you would have to, each person would have to separately climb up it. And of course, this is not a legitimate path of egress. The other way out that currently exists is in the northwest corner. There's a driveway that cars and people can now walk in. There are gates in it, but that is the existing egress. What this map portrays is that a fence will be constructed, which is necessary to isolate the excavation site, and that that fence will prevent people from getting to that existing site of egress. Not only that, but the plan, the TPP plan that the owner has submitted indicates that the 7,000 cubic yards of dirt that is going to be removed there'll be trucks removing the dirt in the area that currently is the egress from the courtyard. So frankly, I was very disappointed and surprised to hear that none of the commissioners seemed to be concerned with the fact that the drawing itself which clearly portrays the path of egress. I mean, it's a small line with arrows in it, but from both buildings, the path of egress is supposed to lead through this opening, which does not exist. And this drawing does not show that. In fact, it's a dual level egress, and Girolamo Street is actually one story above the courtyard level. But this makes it seem like you could just walk out, and that's where the people are directed to go in this drawing. The path of egress points to that opening, which simply does not exist. So I would have thought that the commissioners would be as concerned as we are. My clients are very fearful that, God forbid, in the event of an explosion or a fire and rear egress needs to be used, there's no way out. There's no exit. This is basically a death trap that we're looking at. And I would certainly want to emphasize that as our chief concern. And we did in our argument and Mr. Gross's report. That's certainly the key focus of our report. And this is a very, very frightening and dangerous situation.
Mr. Dobkin, maybe you missed the beginning of our testimony, but what we said was we need a site inspection that is done by the architect who actually goes and verifies existing conditions and does a drawing showing existing conditions and a drawing showing the proposed changes to the existing conditions to accommodate egress, and then how those conditions will be permanently modified at the end of construction. So we can't go on lots of words about this. We have to base this on site inspections and drawings that are properly prepared by the owner's architect. And the recommendation also that DOB and fire department and the tenants do a walkthrough with the architect of the building, do a walkthrough and explain it. So all this back and forth about what the drawings say isn't the same thing as understanding actually how egress will be handled, because you may not understand, for example, and nor do I, that perhaps they're intending to open a temporary passageway through to the street. That's done very frequently in construction projects where they have to make an accommodation for egress we don't have enough information now to comment on the accuracy of the drawings or on whether there have been additional contact with the Department of Buildings about egress. That's why we didn't talk about the specifics of the drawings. We don't have enough information at this point.
May I say something about that? We've submitted 14 photographs that were taken of the existing conditions, which very clearly document the condition of that supposed path of egress, which does not exist, and in fact is a building. And you're in fact, when you open the doors of that, there are actually doors, and then you walk into a closed up space, and you're actually walking into a brick wall. And if you turn right, there's a boiler room and there's a little opening that has no path of egress.
Mr. Dupkin, I don't want you to keep going on about this. We're going to request an inspection by fire department and DOB. You have representatives of both sitting in this Zoom room, and a walkthrough with the architect and the owner's council and tenant group, and any commissioners who are able to attend, or perhaps our compliance officer who is able to attend this, and then we'll understand the situation. We can't go on disembodied photographs and plans, and our interest is not to kill the project. Our interest is in figuring out what's wrong, if there is anything wrong with the safety plan, and correcting it. Commissioner Otley Brown, you had your hand up.
I actually took it back down just now because you just said exactly what I was going to say. I didn't find those photographs to be particularly helpful because it's just too hard for me to conceptualize what direction you're going in and match it to the plans. It was too difficult. So an inspection on site with all three parties would be the best way to resolve this, the quickest way to resolve this.
Yes.
We would love to have the commissioners and anyone they designate come out and look at this, because you'll see very clearly what the situation is. And basically what you'll learn is that in conjunction with the owner's architect's plans, there's basically no way to get out of this building in the event.
We hear you. I don't want to keep repeating this. We have another hearing and I don't want to keep going back and forth and repeating this. So I'm going to ask perhaps Department of Buildings now, and then the owner to testify, and fire department may have conducted an inspection by now, but I don't know. So Mr. Hillwright, please. You're muted, I think. Ask to unmute. You're muted, Mr. Hillwright. There you go.
Okay, you can hear me? Very good.
Yes, yes.
Apologies about my difficulty joining the meeting earlier. Benjamin Hillwright on behalf of the Department of Buildings. Good morning, Madam Chair and Commissioners. I just want to discuss very briefly the history of the challenge permit and the elements and nature of the tenant protection plan here. So the applicant here requests that the board permanently revoke permits for the addition of an accessory subgrade parking lot at the subject premises, which the department respectfully requests that the board deny. The most recent iteration of this challenge permit was issued in March of this year, and it's set to expire next month. The applicant received the first version of this permit in 2014. The current version is the 8th iteration. It wasn't until the sixth instance in this sequence that the applicant brought the instant challenge. I want to take a couple minutes just to quickly clear up some possible misunderstandings or misconceptions about the nature of the tenant protection plan. So tenant protection plans are used to protect safety and health of building occupants and properties undergoing construction. Each TPP must provide the means and methods to be employed to assure such safeguards. This is a continuation of a process that the chair mentioned earlier, the tenant safety notes, which were instituted in 1984. Beginning in 2016, the department introduced a standalone form, the TPP-1, in which applicants have to describe how the work adheres to 6, now 7 required tenant protection criteria. And then pursuant to local law 154 of 2017, which took effect in December of 2017, the local law required that TPPs be made available to the public and the tenants receive notification regarding these. So there are obviously a lot of elements of safe construction that aren't necessarily going to make it into the TPP as we discussed in our submission. For instance, the approved drawings note that this work has to comply with TPPN 10 of 88. which deals with vibration monitoring during excavation work. That requirement was imported into the building code under section 3309.4.4 and is not necessarily referenced in or described in the TPP itself. Per the Borough Commissioner's stamped approval on the additional information form, the AI1, which was submitted on December 3rd of 2018, a site safety manager will be required for the duration of work to supervise construction. And then owners are required per Building Code 3303.10.2 to notify the department 72 hours in advance of commencing any work authorized under a tenant protection plan. So as discussed in our submission, the department holds that the applicant has adequately satisfied all the elements of the TPP in its TPP1 form. That's not to say that that covers every potential or conceivable aspect of safety that's addressed in the building code, though. This building has had some iterations of the challenge permit, as we mentioned, since 2014. Based on the submissions, it appears that there are still some outstanding approvals required from the DHCR that I think are still being challenged, and that situation will need to be resolved, obviously, before any work commences here. All of that being said, I listened to the executive session this morning, and it seems like there are a couple areas of concern for the board, which I'd be happy to address or relay to the borough office for additional review. Commissioner Otley Brown mentioned the possibility of conducting a walkthrough with DOB staff, the applicants, and the owner, which I'd be more than happy to have an inspector attend just to look at any aspects of the construction that are of concern. In particular, the applicant has addressed egress. I just wanted to note, though, that the drawings and tenant protection plan do fairly explicitly say, quote, all existing means of egress for tenants of the building to be maintained clear and free of any obstructions. The representatives for the owner, as they can, I'm sure, attest on their own, stated in their submission that an egress corridor will be created and maintained that will, quote, permit means of egress to Geralman Street through both the existing driveway on the western edge of the site and the small alleyway in the corner of the site. I know Commissioner Shetta mentioned several other concerns regarding the excavation work. Given the nature of this application, I would like to brief those at a future date. I'm not really prepared to speak to those at the moment.
Okay. I think that the issue is, you can fill out forms and you can do drawings, and, in the support of sort of tenants' position of fear, we do have examples of buildings that filed that TP, tenants protection plan form, and then the building collapsed. So obviously something wasn't correct about what was filed versus what happened on the construction site, right? And we do have situations where, even especially now during COVID, I don't want to check when the drawings were done, but site inspections aren't necessarily being conducted so that people are working from memory, as an example, right? So there's a possibility that the architect is recollecting an egress that's not there, that's not been open for years, that's been bricked up or something, right? Or relying, which is done quite often, on historical drawings, because this is an important historical building, right? And so they could have been relying on historic drawings rather than on a site inspection. And in the 19th century, there was indeed a corridor there, and now there isn't a corridor there, right? So the reason that it's not just to send an inspector to check on generally, we want an inspector who's going to be looking at the proposed tenant safety plan and actually verifying that what's shown on the drawings can be done. And if it can't be done, then how are they going to accomplish it? What kind of new work needs to be done in order to actually send you to that egress? So I don't frankly care that somebody checked all the right boxes on a form, because we know there are expediters who check boxes on a form having never inspected the site, having actually no idea about the site. So that's why, to resolve this, we need an in-person inspection with an inspector with the skill set. So that's important to know what a tenant safety plan should look like what required egress is, and not just lip service to our requesting an inspection, okay? And if DOB doesn't do it, we know fire department will be there to ensure that this happens. And I'm certainly going to request Chief Daly have someone attend the inspection, okay? I see Commissioner Shetta's hand up, so please.
Thank you, Chair. I just want to enlighten DOB on like my concerns very clear. Like the chair said, it's easy to check boxes, it's easy to file forms, it's easy to get approvals actually. And then what happens. When I looked at the SOE drawings, it's one of the sections was like really alarming to me. And the concept of partially underpinning this building was like disturbing for me again. And then when you look at the sections, usually when we do that kind of work, when we file with the TA and when we file with the DOB, it's preliminary drawings. But my understanding is that this site is about to go. Construction is ready to go. And when I look at the SOE drawings and I see the adjacent building footing, the drawing says adjacent building footing at this elevation. And then it says VIF, you know, devils in the details, VIF, verify and feel. So that means that this SOE drawing went to the TA and it was approved without verification. It went to the DOB and it was approved without verification. It's been implemented as part of the TPP and the TPP was approved without verification. These are like the small details that cause disasters. So I'm asking DOB to please take a look at the SOE drawings. Especially, I'm gonna give you a drawing number, SOE 202 .00 and 202.00 section 22.
Wait a minute, sorry, say it again. Say it.
SOE 202.00.
Okay.
Section 2. There is no underpinning there in that section. The building footing is set back. This is where I said part of the building is underpinned and part is not. This is the part that is not underpinned. And it shows the building footing and it says VIF, verifying field. I'm not sure if this has been verified or this is just an assumption. And if it is an assumption and they go there and they start digging and something goes wrong, it's not going to be a nice situation. So take a look at that. But I don't want to like scare people. It's not uncommon that people do SOE and underpinning in existing buildings to excavate next to them. But the important thing is this excavation, this SOE is done right. And that's what we're trying to achieve here.
Okay, thank you. All right, so that's an instruction to have your engineers take another look at the supportive excavation drawings, okay? With special attention to that particular drawing.
And if the applicant has not submitted test pits for the adjacent building, making sure that if he says the bottom of footing is at elevation X, he made a test pit and he verified this in field, please ask him to do so before allowing him to excavate.
Okay. Okay, thank you. All right, so any other questions for DOB from commissioners? Okay, Mr. Hillwright, do you want to add anything else?
No, that's it. I think, you know, as I said, we will be happy to take a closer look at those particular drawings, and as soon as it can be scheduled, to assign someone with the proper qualifications to attend a meeting and walk through with representatives from the board, owner, and applicant.
And fire department.
As well, yes.
Right. And before I go to Mr. Fisher, I'm just going to recognize Chief Daly and ask him to unmute. Unmute. You have to unmute yourself. We're still not hearing you. Not hearing you. There you go.
Now you can hear me.
Now we can hear you.
John Daly, Fire Department. I heard the review session, and as Commissioner Hoppy Brown suggested that we do a coordinated inspection, I fully agree. I have a battalion chief who's interested in visiting the site, and I'll get a hold of Mr. Hillwright at the DOB to coordinate an inspection, and also with the tenants and representative for the owners.
Great. Thank you so much.
And Mr. Ricketts from your BSA compliance officer as well.
Great. So I just want to make sure, Mr. Ricketts, you're hearing us.
Absolutely, absolutely. I will definitely be there whenever John notifies me of the date for the visit. Absolutely.
Okay. Thank you so much, Mr. Chief Daly. Okay. So now, Mr. Fisher, please proceed.
Thank you, Chair. And thank you for a very thoughtful discussion this morning. We will, of course, carefully review the comments from the review session and from the public hearing with our design professionals as soon as we can. And we'll address any questions, concerns, and if necessary, any plan amendments once things have been clarified. I do want to assure you that the DOB has looked at this application quite carefully, and in fact, I wanted to remind Mr. Hillwright, he may not have noticed in his review of the plans that the plans actually do call for monitoring, vibration monitoring, which is something that I remember discussing with Commissioner Gluckman directly. We will definitely be present for the walkthrough, and I'll make the appropriate design professionals available. I think it's particularly important that our engineering folks be there and have the proper information available, and the creation of these existing condition plans, and then perhaps more clarity on the TPP and what it'll look like afterwards. I did want to mention to Commissioner Shetta that the work is not imminent. We have the approvals that we need from the State Division of Housing and Community Renewal. There is an Article 78 proceeding challenging that, but DHCR has approved the application and set the financial conditions for it, subject to the work being done in accordance with the approved plans. I also just wanted to mention briefly one other thing. Yeah, so there'll be no work is commencing shortly. Oh, that's what it is. As the chair noted, I believe our permits expire on August 8th. We are in the process of renewing the permits. That'll be based on the plans as they currently exist, since I don't think the walkthrough of the other materials will be available before August 8th. If amendments are necessary, we will file those promptly, and I'll give you our assurance that no work will commence based on those renewed permits until after the walkthrough and the results of that have been processed.
Okay. I believe it's the architect who prepared the tenant safety plan, so the architect should attend as well, not just the engineer. Okay.
Yep. Understood.
Okay. All right. Thank you. Anybody else on this? Any other comments from commissioners? Yeah, Mr. Steinhaus.
We received confirmation from the Landmarks Preservation Commission that except in the context of environmental review, where they review and approve a construction protection plan, DOB is the one responsible for monitoring impacts under TPPN 1088.
Thank
Madam
you.
Chair, if I could be heard for one more moment. I believe that we attached the certificate of appropriateness and the updates to that to our submission. If they're not readily available, we'll be happy to make another copy available.
Right. Now, I think I was just actually referring to the fact that because it's a landmark building, there are special safety precautions that have to be implemented to reduce impact on this historic property and any surrounding ones. So, so historic districts and historic buildings are treated with special care. So, okay, thank you. Mr. Dupkin, is there anything else you wanted to add?
No, thank you. We appreciate your efforts and we look forward to the inspection.
Okay.
I'm just, my real concern is that my wife is ill and I, being in a crowded group, may not, you know, I'll try to wear the correct mask, but I'm
Well,
a little about that.
if you cannot attend, then have somebody else from your tenant group attend, right? It doesn't have to be you.
I've been representing the group for the last 10 years. I will attempt to get someone else though who can attend, and I'll lay it out.
I would recommend that for your safety, and they can report on it. They can take pictures. They can take notes. I'm sure. Okay. Thank you very much. So I don't expect that. Well, we don't know if there's any members of the public who would like to speak on this, but we should open it up to see if there's any members of the public who would like to speak on 2019-90-A, 2432 Joralemon Streets, 102030 Columbia Place in Brooklyn. If you'd like to speak on this, please call in to 646-558-8656, and at the prompt enter meeting ID number 934-5018-3937. So while we're waiting to see whether we have any members of the public who would like to speak on this, I'd like to ask how much time, let's say DOB thinks it needs to arrange for a walkthrough.
I've just gotten in touch via email with John Daly, and we'll do that as soon as possible. You know, I'm hopeful that we could do that. Maybe not before the permit is renewed, but hopefully in the next 2 or 3 weeks.
Okay. And then to allow time for any corrections to the drawings and so on, maybe another 2 weeks for Mr. Fisher's consultants to make corrections, 2, 3 weeks, 6 weeks, say, total?
That sounds about right.
Okay, so we're talking, I'm asking these questions because it helps inform when we would have the continuation date, which we'll assign in a couple of days, but gives us an idea for when. So maybe a total of 6 weeks to submit response. Does that sound good? And during that time, the walkthrough will have occurred and any required changes to the drawings will have been made. Okay? All right, great. I don't see anyone in the waiting room, correct? Okay.
Nobody has joined.
Okay, thank you, Kurt. All right, so thank you very much. We appreciate your participating in this Zoom hearing, and we hope to get a quick resolution on this problem.
Thank you.
Okay, thank you. Bye.
Item number 21, 2019-295-BZY, 428-432 East 58th Street, Manhattan.
Any signs of Kramer-Levin? So this is a Kramer-Levin case. Someone from that office. Don't see anyone. I don't know who's the counsel representing on this one. Do we know?
I believe it's Gene Travers.
Oh, here he is. He's in the waiting room. Okay, good. Thank you. Thank you, Chase. Okay, Mr. Travers, when you can hear us, please state your name.
Hi, good morning, Eugene Travers with Kramer-Levin. Gary Tarnoff is about to log in as well.
Okay, should we wait for him or?
I think we should.
Okay.
I'm in communication with him right now.
Is anyone else from your team joining?
I believe it's going to be just Gary and me to start.
Okay, so we have 2 people so far in the waiting room who may want to be giving testimony later, but I don't see Gary yet.
He received a message that says the host has another meeting in progress. I've asked him to try it again.
He's on the wrong, probably on the wrong dial-in. So he doesn't have to come into Zoom. He could just dial the phone number and speak if that's easier for him. So maybe just
Okay.
tell him to call 646-558-8656. And I'll give you the ID number when you're ready.
I'm texting it to him right now.
Okay, 934-5018-3937. You got that?
I do. Yeah, I've conveyed that to him.
Okay.
Just give him 30 more seconds. In the meantime, Chair, I can respond to 2 comments about the board's prior resolution. That was actually contained in our July 23rd submission. So the board should have that. The board should have that in the record. And in terms of status of litigation, there hasn't been any update beyond the summary that the board's already received.
Mm-hmm. So you haven't been assigned a hearing date or anything like that?
Yeah, the last item in that summary is current.
I don't know, we have 3 names. I'm assuming Mr. Tarnoff's name would be not Chaim or Merit. There are 2 people in the waiting room.
No. Is it possible to call his number to try to patch him in?
I'm not aware of any way.
We could do that if you have a number to call.
Oh, right, the invite, yeah.
If you just email me.
Okay, let me do that, Kurt. Appreciate the accommodation.
The problem with this is he needs to recognize the phone number, which is a 646 area code, and I actually forgot the rest of the phone number. Otherwise, he'll think it's a junk call because it doesn't come from Kurt. It comes from a 646 area code.
Well, we were all watching the review session. So I'm sure he's trying to log in, so I'm sure he'll answer.
Madam Chair, do you need the number? It's
the number that shows up on your screen when you get called with an invite.
Right. It's 646-558-8656. Is that the number?
No. That's the number you call to dial into a Zoom conference.
I see.
You can hit that invite button on the lower right corner of the screen and you can call someone, but then it's Zoom that makes the phone call. And that's some kind of 646 number that actually, oh, you know what, I might have it. Oh, yeah, I do have it. It's 646-568-7788. That's the number that will call as an invite. Or that's the one that called last time we tried this.
Kurt has his cell phone. I don't know if he's able to patch him in now.
Well, it wouldn't be a patch in. He has to then, the invite turned out to not work very well, so we abandoned that as.
Not received the email yet. Oh, it just showed up.
By the time we go back to in-person hearings, everyone will have the hang of Zoom, I'm sure.
I don't know when that's going to be, so you better get the hang of this.
We're all working.
Oh, there he is. Okay, Gary is on. Hi, please state your name.
Gary Tarnoff.
Okay.
Prayer 11 F House in Franklin, LP. I'm sorry for the delay. I think I had the wrong ID number. I tried 3 different devices and I couldn't get into the meeting. I did hear the review session this morning, and I heard the chair's discussion of the application vis-a-vis the findings. I don't have anything to add about how we meet the findings, which are addressed in our application, and I think which the chair described. The chair asked about the status of the pending litigation. There is really nothing to report beyond the description that we gave you as part of our submission. Justice James denied the Article 78 petition on January 8th, 2020. There was a motion to re-argue on February 21st, 2020, and a notice of appeal was filed. I believe the motion to re-argue has been fully submitted to the court, but we haven't heard anything further on that. The notice of the appeal has not been perfected to date, so that has not been scheduled. I don't think the briefs have been exchanged as of yet. The other issue that the chair discussed during the review session had to do with the applicability of the state provisions in section 11.332. We couldn't find any board cases dealing with that issue, and I think it typically gets dealt with at the Department of Buildings. We've asked for a 2-year extension from November 30th, 2019. I must say, I think it would be, I don't think that the chair's reading is necessarily a reasonable one, because it seems illogical that there would be a stay for litigation pending during the second 2-year extension rather than the initial, during the initial 2 years to complete this construction, a litigation does not stop the time from running. I think I think the statute, the toll period was just put in 11.332 for administrative convenience. It's all part of the same scheme. In fact, the first paragraph of 11.332 cites the 11.331. But as I said, I think that's something that can be dealt with at first instance at the Department of Buildings. We've asked for a 2-year extension from November 30th, 2019 at this board.
Okay, I don't think it really matters anyway because you filed timely, so it actually doesn't matter. I
agree.
Okay. Okay. Anything else you want to add? Any questions from commissioners? Anybody? No? Okay. All right. Anything else? Because I'm going to go, we have 3 people in the waiting room who I assume want to testify on this. So we're going to admit them and invite others to testify. Okay?
Okay, I don't have anything to add.
Okay, thank you. So I'm admitting all 4 people, it says in the waiting room, but I only see 3. And anybody else who would like to testify on this case? All right. Anything else? Because I'm going to go, we have 3 people in the waiting room. Please turn off your YouTube video. I'm going to admit that and invite others to testify. Please turn off your YouTube video. Everyone who was just admitted into the Zoom hearing, you must turn off your YouTube video. And also we're inviting others to participate. If anybody's watching on the YouTube video, please dial in to testify on case number 2019-295 BZY, which is 428 to 432 East 58th Street in Manhattan. You can participate at 646-558-8656, and at the prompt, enter Zoom meeting ID number 934-5018-3937. Okay, so we have someone who's identified as Merit, M-E-R-I-T. Can you unmute yourself, and hopefully your YouTube video is off, and state your name, your full name. Merit, please state your name. Not getting a response. There we go. No, don't know what happened to Merit. All right, I'm going to move to someone identified as Chaim. Please unmute yourself and identify yourself with your full.
Yes, I'm here for a 24 Gerolman Street. I might be have been entered from the waiting room, perhaps improperly.
So we already heard testimony on Gerolman, and you didn't dial in when we were listening to testimony.
Oh, I was perhaps in the waiting room or didn't call in. I'm sorry about that. Okay, I will.
Okay, if let's see, you can listen to the replay of the YouTube video, which will be streaming in replay form, I guess, by later today or tomorrow.
Yes.
Okay. Thank you.
He can submit his testimony like via email as well?
Yes. And you can submit your written testimony if you want to submit at, how's it go? Submit at bsa.nyc.gov.
And the board will be posting on its website when the next hearing will be, and you'll have the opportunity to appear there as well.
Okay, so there is a follow-up on that hearing?
Yes.
Okay, submit at bsa.nyc.gov.
Correct.
Thank you very much.
Thank you. Sorry that you missed the.
Sorry.
Okay.
Okay, thanks.
Okay. We also have someone named Jennifer. I can't see. Choik. Oh, that's an.
Yes.
Yes. Okay. Are you here to testify on 428 East 58th Street?
I'm here to answer any questions the board members have, if they have any. I'm the architect for the project.
For 428 East 58th?
Yes.
Okay, thank you. We're trying to find people who want to give testimony, so they seem to have vanished. We see anybody else?
I do not. Should we share the screen again, just in case?
Yeah, let's try. So, quite strange. We had 3 people in the waiting room to testify, and now they dropped out. So if anyone would like to testify on this application, 2019-295BZY, 428 to 432 East 58th Street, Manhattan, please dial in to telephone number 646-558-8656 and put in the meeting ID number at the prompt, 934-5018-3937 #. We'll give it another 30 seconds because there's a time delay. Okay, all those people. Okay, then. So I don't think we had any other outstanding issues, and there seems to be no testimony, public testimony. So I then would like to make, does the commissioners have a problem with us closing on this? I see no objections. Okay, so I'd like to make a motion to close.
Chair Permiter,
Aye.
Vice Chair Chanda,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Shabeta.
Aye.
Okay, and we'll try to put this on for decision as quickly as possible. There are no submissions needed. So that's the situation. Thank you very much, everyone, for calling in.
Thank you.
Thank you.
Thank you.
Okay, take care.
This concludes the public hearing for 10 a.m.
That's how the PSA closes its hearings. All right, see you all at 2. Thank you.